Hello, everyone, and welcome to our discussion today of the international law around fake news and hate speech. Now, this is, of course, as you all probably know, an emerging format of international law that's evidenced oftentimes through customary international law, but there is some case law and some treaty law that we'll also look at today between the ICCPR, the cases of the ICTR, which is the International Criminal Tribunal of Rwanda, and other sources of international law that actually discuss international law and its relationship to hate speech, incitement to violence, and fake news. Now, before we start, one thing to remember that the first part of our lecture today will be talking about hate speech, right? Now, hate speech actually can come in or has a few different flavors or related sort of issues or topics to think of. Now, we have hate speech that can be around religious, hate speech that can be around communal, hate speech that can be around racial, ethnic lines, political lines oftentimes as well, and you can also have incitement to violence. Now that's a separate kind of issue than hate speech itself. Hate speech is something that offends someone, that tries to sort of to criticize them for who they are or what group they belong to, whereas incitement to violence is actually the next step. It's this person is bad or X, Y, and Z, and that's why we have to hurt them, and that's why we have to carry on attacks of them. So keep sort of that distinction in mind as we go forward, because under American law, at least, the prohibition really that the state has provided is for when speech is actually inciting violence. But when it's just hate speech in and of itself, that might not necessarily be something that could be prohibited, because the United States really values the freedom of speech, the right to expression, et cetera, et cetera. And actually, we'll see this conflict play out between the right to freedom of expression, but the right to also prohibit or punish forms of hate speech under international law between ICCPR Article 20 and Article 19. So let's go ahead and get started with the lecture, and I'm going to share my PowerPoint with you all on the screen. If you just give me one moment for it to load up. Go. Okay. Let me just load up the PowerPoint. Sorry. So let's take 1 second. Okay. So again, like I said, we're going to be talking about fake news, hate speech, and international law. And so let's go into the moot court competition that's really going to be impacted by this set of issues. So this Nepal moot court competition, and of course, I can't provide too much guidance for you all, or even specific sort of examples that you could use for this competition, but this lecture is geared towards getting you all ready the competition. And what we have there is a social media website. Think something like Facebook, MySpace, something like that, Twitter maybe, where users are sharing hate speech and they're sharing fake news. So remember, with social media websites, it's not the people who are running the websites that are creating the content. It's actually third-party users or people who are actually utilizing the platform to publish their own ideas or to publish their own opinions. So there's a little bit of a difference there between what we've seen traditionally under international law previously, like with radio stations or TV stations. You know, if the person who's running the radio station or TV station, or the person who's carrying is the same person who's carrying out and saying content that's discriminatory or is hate speech, then what we have is a little bit different than when we have a platform where people are writing things themselves, but the company is literally just hosting a site or a place where people can post those things. So there's a difference there. And on this social media website for the Nepal moot court competition, there's users who are sharing a lot of hate speech and fake news, and that actually hate speech and fake news is causing an increase of hate crimes against a certain group. Now that hate speech and fake news is geared towards targeting a certain group, and that group is now facing hate crimes in a country. So what is the responsibility of the social media website? What is the responsibility of the country where that social media website is incorporated? Now, one big difference also from the competition to what we have in oftentimes with Facebook or Twitter is that the social media website in the Nepal moot court competition is actually partly owned, and its policies are administered by state officials. So Facebook is incorporated in the United States, but for the most part, they actually operate and create their own policies independently as a private company. Therefore, that's why we can't really hold the United States liable, for example, at the ICJ for something that Facebook might do. But here in the Nepal moot court competition, we have a different kind of platform, and that platform is partially owned by a state and it's actually partially controlled by a state. So it's a little bit unique and something to keep in mind. Now, one thing to remember is that we're trying to draw a line here, and many countries are trying to draw lines between hate speech and free speech. there is protections of freedom of expression under international law, freedom of speech under international law, but then there's also things under international law that allow and then sometimes encourage countries to prohibit hate speech for various reasons, and we'll go through some of those reasons later on today. So let's go back for a second, and actually let me take off the screen for a moment. One of the things to remember here, I think, that's very important is that both of these rights are important. Freedom of expression or speech is very important. In fact, in the United States, it's almost looked at as an absolute form of freedom of rights to freedom of expression, where even things that are really offensive to people might still be covered by freedom of expression or freedom of speech. On the other hand, we have the European model, and other countries, including the African Union, countries in the African Union and in South Asia and in Asia, have adopted provisions that can punish people for engaging in hateful speech. Even though those same countries do protect the freedom of speech or expression, they at the same time want to protect minorities, the dignity, the self-respect of others. And these aren't just hippy-dippy kind of words that I'm using. Dignity, self-respect, the right to identity, these are all international legal norms that have to be protected. They're human rights that have to be protected. So when speech actually impacts the listener in a way that degrades them, that causes discrimination amongst them in their society, that dehumanizes them, that subjects them to violence, all of those things can actually oftentimes be prohibited under domestic law, which is in accordance with international law, right? So let's go back to the PowerPoint. One of the things that Americans are talking about, and even amongst Americans, you see racial groups have disagreements on this. Can society prohibit hate speech while still protecting free speech? And you see that all respondents said around 50% yes, they agree, 56% rather. White Americans, 50%, African Americans, almost 70%, and Hispanic Americans, almost 70%. So oftentimes what we see here, I think, is that the targeted groups are African Americans and Hispanic Americans for hate speech under the US as it currently exists. And those groups are the ones who agree, essentially, that we should be able to prohibit hate speech while protecting free speech. Now, this isn't just a racial issue, and this doesn't break down along racial lines. International legal experts, international human rights attorneys, civil rights attorneys from around the world actually disagree on this, and there's reasonable minds that can disagree on where the line should be drawn between free speech and preventing or punishing hate speech. I also wanted to include an example of a police force saying that essentially we're using comments on social media essentially to potentially prosecute individuals. Now, it says here from Police Scotland, please be aware that we will continue to monitor comments on social media, and offensive comments will be investigated. So that's an important thing that oftentimes countries are trying to adopt new provisions and new laws that would allow them to prosecute or to punish individuals who use social media or online websites to engage in offensive comments or hate crimes. Now, of course, on the other hand, police could be using this to, and I would be remiss if I didn't provide you the other side of this argument, right? And the other side of the argument is essentially oftentimes when we're giving the state this right to determine what hate speech is, they can expand that to such a degree that they can just shut down unfavorable opinions that they don't like or agree with. And that's not the same thing, and not always the same thing, as preventing or punishing hate speech or incitement to violence. Of course, hate speech and incitement to violence have characteristics that we can look at. But oftentimes what we're afraid of on the other side, from the freedom of expression and freedom of speech side of things, is that how far are we willing to give this right for content moderation, essentially, or for punishment of content online to countries, right? And it's a very major issue that we're still working out. And I just wanted to provide that alternative idea to you on the other side. It's not just about trying to create punishments and prevent hate speech. It's also trying to stop the state from engaging in something that's perhaps going to stop people from being able to feel free in discussing issues, right? So let's keep going with the PowerPoint. Let's look at ICCPR, freedom of expression. That really comes from the Article 19. And Article 19 actually has 3 different subsections. The first subsection talks about the right to hold opinions. The second subsection talks about the right to express those opinions, essentially the right to freedom of expression. And this right should include the freedom to seek, receive, impart information and ideas of all kinds. So remember when I was just talking to you about what the state should and shouldn't be able to limit? Here, the ICCPR Article 19 is giving you very expansive sort of rights for a human being that the state shouldn't infringe upon. And these include the freedom to seek, receive, impart information and ideas of all kinds. Does it say ideas that are politically correct at the time? No. Does it say ideas that are favorable by a certain government where an individual is living? No. It says ideas of all kinds. So that's an important sort of overall sort of thing to keep in mind of the ICCPR subsection 2 talking about all kinds of ideas. And it can be through many different forms. It can be orally, it can be through writing, it can be through print, it can be through art, and it can be through other media of his or her own choice. Now, I think some may disagree, but I think many would think that this actually does include social media as well. Since social media has proliferated so much on these platforms that I mentioned earlier on, Facebook and Twitter, I think that perhaps we could cover social media under this as well. And therefore, you have the right, essentially, under ICCPR Article 19, 1 and 2, to express and to hold an opinion and to express that opinion and to receive information without limitations by a state. Now, Article 19 also comes with subsection 3. Subsection 3 actually limits some of the rights we were just talking about, right? One of those rights being, of course, as we see, the rights, rather, they talk about this right comes with special duties and responsibilities, okay? So keep in mind that it's not just a right, it has associated duties and responsibilities. So restrictions by governments can be created, but they have to be provided by law, first provision. Second provision, they have to be necessary to respect the rights or reputations of others, or the protection of national security, or public order, or public health, or morals. So let's look at the first one. For the respect of the rights or reputations of others, that's talking about the right to dignity, the right to self-respect, the right to self-identity for individuals, oftentimes minorities in certain countries who are being targeted by hate speech. And the second part talks about protection of national security, public order, public health, or morals. Now, if it seems like to you that national security, public order, or public health or morals could be used to essentially justify almost any limitation placed on freedom of expression, that might make some sense. In fact, what we've seen from the European Court of Human Rights, as we'll talk about it in a few moments, is that they've actually deferred to the determination of a country when they're trying to place limitations on freedom of expression by creating hate crime, or rather hate speech and incitement to violence punishments for individuals. They're oftentimes given deference as a state to create those limitations on freedom of expression so that they can fall under this very broad exception of national security, public order, public health, or morals. Okay, so keep all of that in mind as we go forward. Now, one of the things to remember that I think we oftentimes, American lawyers might not necessarily understand the importance of, because it's not something we look at, but hate speech is not free speech, right? Every time hate speech is permitted, it costs someone part of his or her own self, part of their self-respect, part of their sanity. It rips people to shreds and destroys societies. Now, this isn't just being hyperbolic, and this isn't just saying that hate speech is bad. Rather, it's, I think, making a very important point here as we look at this examination of hate speech as in conflict, perhaps, with the idea of free speech under international law. So we have to move beyond American law. And so I'll give you an example, or I'll rather give you an explanation of how we look at it in American law. In American law, if there isn't an incitement to violence, if there isn't something in the speech that's essentially causing the other person to, or causing people to commit violent or illegal criminal acts, it might not be prohibited by the state, or might not be permissible to be prohibited by a state or locality. Whereas under European law and under international law, actually, there's a really great sort of importance placed on the listener. So while in the United States we talk about the intentions of the speaker, the impact on the society at large or the group that they're talking to, the international looks also at the impact on the speaker. If the speaker is feeling as if their dignity, their self-respect is being damaged by certain kinds of speech, then there is permission for that speech to be prohibited or punished by a country. There's nothing under international law that wouldn't prohibit that. And in fact, what we see in Article 19, 1 and 2 can actually be juxtaposed with Articles 19.3 and Article 20 of the ICCPR, which I'll talk about in just one second. Article 20 is a very important article that we should talk about. Let's see, one moment. Okay. So, as I mentioned, Article 20 is very important, and it talks about hate speech, essentially. So Article 20 says that any propaganda for war shall be prohibited by law. But let's go to the second one, which is more important, I think. Any advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence shall be prohibited. Okay, so let's look at the first part of that. Advocacy of national, racial, or religious hatred. That's quite broad, and it covers a great deal of the hate speech that's happening today in the world. It's based on nationalistic terms, it's based on racialist or racist terms, or religious hatred, right? And then we have to look at what is it causing, right? So it's the incitement, and it's not just like I mentioned to you all earlier about the American law, how it's an incitement to violence. It's actually an incitement to discrimination, hostility, or violence. So it can be any one of those three that actually is impacted by the spreading of hate speech or the spreading of incitement of violence or crime against individuals belonging to a national, racial, or religious group that's being targeted, right? So if we take, for example, let's see, let's take, for example, some of the online comments that have been posted in Burma and in Myanmar, right? What Facebook and rather not what Facebook, what the UN and a lot of other international organizations found was that actually the propaganda for war, which we talked about in Article 20, and the advocacy of national, racial, and religious hatred was actually being fostered against the Rohingya Muslims on Facebook and on social media websites. And that's what essentially led up to the commission of genocidal acts against the Burmese or against the Rohingya living within Burma. So what we have here is essentially both things happening. We have propaganda for war that was spread by Burmese state officials through Facebook, through Twitter, criticizing Rohingya, dehumanizing Rohingya, and then also advocating for war against Rohingya, right? And then on the other hand, we also have the advocacy through national, racial, or religious hatred that caused incitement for discrimination against the Rohingya, the hostility that was socially proliferating against the Rohingya, and violence eventually that was actually committed against them, where thousands of people were killed, many hundreds of thousands fled to Bangladesh. So actually that's one example in modern law that we can look at, or modern international relations that we can look at, that talks about this issue, or talks about a commission of this issue. Okay, let's move on to the next slide. So let's go to the European Court of Human Rights now, right? Because I think the European Court of Human Rights actually has a great deal of jurisprudence that we can look at for limitations that have been put on freedom of expression, freedom of press, and all of these things. So this hyperlink that's on this window will actually be shared with you all, as well as a PowerPoint. But this actually has a compendium of resources, of cases that the European Court of Human Rights has actually done to talk about hate speech, to talk about incitement of violence for religious, racial, or ethnic lines, right? So what they say about restrictions on the right to expression is that they have to be deemed necessary, right? So they have to be necessary for the interests of 1, national security, 2, public safety, 3 and 4, the prevention of disorder or crime, and the protection of health or morals. And then finally, the protection of the rights and freedoms of others, right? So we have actually 5 different provisions here that's a legitimate interest for the state to engage in when they're doing limitations on freedom of expression, right? So we have national security, public safety, prevention of disorder or crime, protection of health or morals, and the protection of the rights and freedoms of others. Now, let me give you a few examples, perhaps, that might actually be helpful to you all when you look at examining these kinds of limits on freedom of expression. So national security. Let's say that there's a terrorist group, essentially, right, that's engaged in a civil type war against the state, and many of the individuals of the state belong to a different racial or ethnic group, and that's the group that the terrorist group is attacking. And let's say that somebody from that group goes on social media, goes on the radio, goes on press, and says that we have to crush these cockroaches that are confronting us, and everyone should be supporting our terrorist group, right? And then he goes on to another radio station and he says, support our terrorist group because we're killing off these X, Y, and Z individuals. So if a law is passed in that country, right, that says to protect national security, we don't want these messages to be spread, we're going to actually limit the freedom of expression, limit the freedom of press, limit the freedom that we're talking about here, in order to ensure that the country maintains its national security. So if that case went before the European Court of Human Rights, likely they would say, sure, that's actually probably a right limitation on the freedom of expression. You haven't violated international law because you're valuing expression, but you're also prohibiting violations to national security, which is a legitimate interest under international law. So let me give you a different example, right? Let's talk about the protection of health or morals. Now that might seem weird, but let's say that oftentimes what's happened in Pakistan, for example, is that polio drops were being sort of given out to individuals. And at some point, fake news started to be spread around that the polio drops were actually some kind of infertility drops being spread by the American government and the Europeans to make the people infertile of that area, or that they were somehow going to turn them into brainwashed individuals. So fake news was actually being spread a lot to say that that polio drops shouldn't be taken by individuals. Let me give you another example. The spread of Ebola actually happened partially because individuals who were spreading disinformation online and fake news online were actually doing things like saying that Ebola is not transferable by touch. You can actually avoid certain sort of ways to catch Ebola, or you can try certain remedies for Ebola that actually spread the disease more. So if a country that's undergoing a national health crisis, like an Ebola sort of attack, what they could actually do is create laws and limitations on people spreading this kind of false information or fake news, right? And so that would actually be a permissible restriction on the freedom of expression. So keep that in mind. And let's actually look at an example from the European Court of Human Rights that looks at freedom of expression in practice, right? And limitations on freedom of expression in practice. Now, one thing that I can tell you is that the link that I put here gives you a compendium of all the cases. And essentially, in most of these cases, like I mentioned earlier, the European Court of Human Rights is actually deferring a great deal to state governments who are creating limitations on freedom of expression in order to ensure national security, stop hate crimes, ensure the protection of the rights and freedoms of others, of minorities. So actually, oftentimes, the European Court of Human Rights gets an appeal of a punishment for a person who's committed a hate speech or committed incitement to violence against an individual. And actually, the European Court of Human Rights says, no, we're not going to actually judge this because the state probably was right in what it did in creating a limitation on your freedom of expression, but it did it because it was necessary for national security, public safety, order, et cetera, et cetera. So let's do one example, right? Let's go to Turkey, which had a case before the European Court of Human Rights from Erbakan, where the court said tolerance and respect of the equal dignity of all human beings constitutes the foundation of a democratic, pluralistic society. So let's take a second, let's pause for a second, right, and think about the importance of that. They're talking about the foundations of a democratic, pluralistic society, but tolerance and respect for dignity of all human beings is actually a part and parcel of international law, right? Human dignity and self-respect and self-identity are rights that are actually enforceable in international law. So the court actually talks about foundations for a democratic, pluralistic society, but actually, I would actually go further and argue international law also is based on equal dignity for all human beings being a foundation of international law, rather. And so let's go forward. And so what does that mean? Well, if tolerance and respect of equal dignity of human beings constitutes foundations of democratic, pluralistic society, so what? The so what is that countries can actually, it may be considered necessary in certain democratic societies to sanction or even prevent all forms of expression, which spread, incite, promote, or justify hatred based on intolerance. Okay, so that's a very huge permission for countries like Turkey to stop hate speech, to stop speech that violates the dignity of other human beings living in that country, even when there is a freedom of expression and right. But here's the catch-all, and here's something that has to be put in place as well. If there are limitations to freedom of expression, or there are restrictions or penalties, they have to be proportionate to the legitimate aim pursued. So a country can't just say, hey, we're stopping certain kinds of speech because it impacts our national security. No, they actually have to prove that the limitations they're putting in place are actually proportionate to a legitimate aim. So they're proportionate to protecting national security, protecting order, protecting health and morals, et cetera, et cetera. So the proportionate element is actually a new idea that I'm putting, that comes from, not that comes from this, but that we know exists under international law, that the aim of the country has to be legitimate. It can't just be to shut down opinions they don't like. It has to be related to national security, the rights of others, et cetera, et cetera. But then the action has to be proportionate as well. And that's an important caveat to add, because you can't just create blanket limitations on freedom of expression and say, oh, it's national security. You actually have to put proportional elements in, because whatever problem you're trying to deal with, you have to do it in a proportional manner. Your resolution, the law that you're creating, the policy that you're creating has to be proportionate for that legitimate aim. Okay, let's keep going. So let's actually talk about, because we've talked a little bit about domestic law, especially with the United States, but let's talk about international law and where international law has been used to punish individuals who engaged in hate speech through a different medium than social media. We're looking actually here at the radio. And essentially there was a radio station, RTLM in Rwanda, and that was essentially one of the stations that broadcast a lot of hate messages, calling the Tutsis cockroaches, calling for the extermination of those individuals, and orchestrating attacks through the use of the radio as well. And one of the slogans they used to broadcast, which should be terrifying, and it is terrifying, is that the graves are not yet full. So actually what we have is that the Rwandan genocide happened, and then international law came up with another resolution rather than just having the case go to the ICJ, right? So this is where it's a little unique, and I want to kind of mention this to all of you that don't have experience looking at ad hoc criminal tribunals that have been created. So there's been a few ad hoc criminal tribunals created: the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and this is the one we're going to be talking about today, the Rwandan one. But essentially, these are sources of international law. Under the statute of the ICJ, sources of international law include judicial decisions, and judicial decisions by a fellow international legal body like the ICTY can be used before the ICJ. So don't feel that you can't use it because the ICJ didn't decide this case, but we do have a case about hate speech being spread by radio personalities and radio leaders that caused them to actually be charged with genocide and incitement to genocide. So let's keep going forward. One of the examples, or one of the three individuals who were actually prosecuted under this prosecution effort, essentially by the ICTR, was a founder and director of RTLM, which was Ferdinand Nahimana. He used the hate radio station to spread hatred, organized the genocide of Tutsis, referred to Tutsis as cockroaches, and there was some obvious undertones to his speeches, but also in some there was hidden messages like cut the tall tree, which is essentially a call to arms for individuals to start slaughtering Tutsis by Hutus. So that actually had a direct causation, or there was an actual involvement of direct violence, genocidal violence, actually, based on the things that he was saying on the radio on the radio that he had with the RTLM. So they broadcast messages that were anti-Tutsi, that dehumanized Tutsis, that called for attacks on them. And in 2003, the three top leaders were found guilty. And here's the interesting thing. They were found guilty not only of incitement to genocide and conspiracy and crimes against humanity, but genocide itself, extermination and persecution. So all of the things that were underlying this case, genocide, incitement to genocide, conspiracy and crimes against humanity, extermination and persecution, were what they were found guilty of. So that's an important distinction to be made, and actually an important point to be made. While we don't have a lot of, perhaps, and there might be arguments that there isn't much international law that's binding as it relates to stopping hate speech or stopping speech that's dangerous, like the one that we saw in Rwanda. We do have an example from an international criminal tribunal that actually does examine this issue in a critical way. And it actually comes up with an interesting rule, not only with regards to holding these individuals liable for genocide and for incitement to genocide, but also they had an interesting conversation that I'll talk about in a moment here in the same case. They actually laid out, well, actually, before I go there, the judgment essentially asked for people to distinguish between the discussion of ethnic consciousness and the promotion of ethnic hatred. They're saying, the court was saying, essentially with ethnic consciousness, the knowing about your ethnicity and the spreading of knowledge about an ethnicity is not necessarily something that should be prohibited. That's under freedom of expression, but the promotion of ethnic hatred actually can be prohibited by international law. So let's look at actually an example of what the chamber looked at. The chamber looked at important protections of international law with freedom of expression and noted that the prosecution presented an example that actually was protected by this right and could not have been prosecuted, and should not have been prosecuted, rather. They said that there was an interview of an individual on RTLM which talked about a moving personal account of his personal experience of discrimination as a Hutu. So instead of saying Tutsis are not human, they're bad, they're cockroaches, they're X, Y, and Z, here this individual was actually being interviewed to talk about feelings of discrimination as a Hutu. So that actually would be covered under freedom of expression and shouldn't be prosecuted by the ICTR, which is what the chamber found. Whereas the actual things like cut down the tall trees, the Tutsis are cockroaches, all those things, those are different because those are incitement of hatred versus discussions about ethnic consciousness, right? So that's a difference that has to be made, and one is covered by freedom of expression and one is not. But let's go back for a second and actually talk about some examples from the broadcast that are actually very disturbing. And I apologize to anyone who hears these and is impacted by it, but these are extreme examples of hate speech being spread. One of the journalists on one of the broadcasts in RTLM said, look at the person's height and appearance and physical appearance, just look at his small nose and then break it. Of course, they're not just saying to break the nose, they're saying to do other physical violence. And then the statement that was, it's almost time for us to cut down the tall trees, which again was a code, a cipher to individuals to go kill Tutsis, the Hutus who are listening to the radio station. Now, this is actually a very fascinating clip that I have here. This picture is from a play, and then it was filmed and turned into a film called Hate Radio, which essentially followed the story of the individuals running this radio station and how they played such a strong and really evil role in the Rwandan genocide of the Tutsis. So that's something to keep in mind. And these are the examples that we can find here of radio being used by these individuals to, spread hatred and cause violence. So one of the things that the ICTR said is that the power of the media to create and destroy fundamental human values comes with great responsibilities. Those who control such media are accountable for its consequences. So here again, along with, just like in Article 19, subsection 3 of the ICCPR, the ICTR is saying freedom of expression doesn't come without a price. It comes with duties and it comes with responsibilities. So you have to exercise that right in a way that doesn't violate those duties and responsibilities, right? And so it's an important distinction to be drawn from the more expansive way in which American law looks at freedom of expression and freedom of speech as being unencumbered by any kind of duties or responsibilities. International law, as stated by the Article 19, subsection 3 of ICCPR and this ICTR judgment, it does look at essentially, the power of the media to impact major conflicts like this, and that those individuals should be held accountable for those consequences. Okay, so let's keep moving on. Well, before we move forward, I think it's important here to distinguish the case, because it's always important for moot court for you all to know how to distinguish the case. In the Nepal moot court competition, we have something like a Facebook, a MySpace, a Twitter type thing, where it's not the people who are actually running the website that are creating the content, it's actually users using the website creating the content. However, that's very different from what we had with the radio station. The radio station, the copy that was being read out on the radio station, and oftentimes being read by the person who was actually one of the 3 people who were the founders of the radio station. So the founders are on the radio station, they're spreading the bad sort of speech or the hate speech on their own. For Twitter, for Facebook, for all those, it's not the individuals who are running those corporations, it's the individuals who are using the platform. But keep in mind that we have the example that I mentioned earlier on with Burma and Myanmar, with Facebook being used as a way to dehumanize Rohingya, to facilitate violence carried out against them. Facebook actually did take action against several hundred, up to 1,000 Burmese officials who were using their personal Facebook accounts in order to spread hate messages. And Facebook was actually able or did moderate that content, delete a lot of their posts, and also delete some of their entire profiles and accounts. So that's an important thing to remember, that Facebook, while it's not like the radio station with RTLM, it does have an element of control for moderation and content moderation, and it does exercise that in some instances. What we've seen, and what the international community oftentimes gets frustrated with, is that they don't, that there isn't enough content moderation, that they don't do enough to go and stop hate or incitement to violence against racial or ethnic groups. And oftentimes, as we're seeing, these mass killings, these atrocities carried out against individuals are happening because people are using hate speech through social media to normalize really atrocious behavior and set the precedence for atrocious behavior and atrocities to be carried out against groups. So the last thing we're going to talk about today actually is looking at how to spot or looking at fake news and how international law has addressed fake news. I think the very quick thing that I can mention to you all is that there is emerging perhaps issues or duties of international law as it relates to fake news, but really it's a very soft source of law. There isn't hard law here that requires countries to do X, Y, and Z to stop fake news, but we do have something that we can look at. But before we go there, I thought it would be important for you all, because fake news isn't just for the public consumption. There's oftentimes fake news even about international law, public international law, human rights issues. And so I wanted to include this infographic, which I thought was really great, about how to spot fake news. So one thing to do is consider the source, make sure that it's a credible source that you're looking to. Go beyond the headline, because oftentimes, of course, as you know, fake news websites oftentimes do create clickbait headlines. And so you have to go beyond the clickbait and see what the story actually says. See if the author is reputable. Are they credible? Are they real? Have they written other things on this subject before? Look at supporting sources. Oftentimes articles will come with cross hyperlinks within the article itself. So you should go to that and see that, whether it's reasonable sources and legitimate sources. You should check out the date. That's oftentimes how fake news is spread. People look at old news that might be fake and then spread it when a new story is coming forward, and then that kind of creates more conflict. Look at whether or not it's a joke. You know, there's oftentimes satire websites like The Onion, where if you looked at it, you might really get scared because you might think something is true when it actually is fake news. So again, that actually goes back to consider your source as well. Check your biases. Oftentimes what we see with fake news, we want our own biases confirmed by the news that we see. And so we have to try and check our own biases before we try and see whether something is fake or not. And then ask the experts, right? Ask a librarian, ask a consult a fact-checking site, law professors, blogs by law professors, and articles by law professors, especially through whatever database you can look. They can oftentimes be credible, vetted sources of information that can help you spot something that might not be fake or might not jibe with reality, right? So where can we find something that talks about fake news in international law? And I think one of the things that we find, other than a lot of scholarly opinion, and I want to take a moment here and stop the PowerPoint presentation to mention that this area has actually been very, very deeply explored by various scholars in the field. The impact of fake news on international law, or the impact of international law on fake news, rather, is something that's been discussed by a lot of scholars. So if it's something that comes up in your moot court competition, as it likely might with Nepal, it's something you should definitely consider looking at the scholarly opinion beyond just hard sources of international law like the ICCPR. But here I give you one example of a perhaps soft source of international law, but still something that you can use. It's a joint statement from the United Nations Special Rapporteur on Freedom of Opinion or Expression, the OSCE, which is the European International Organization, Representative Freedom for the Media. There is the Organization of American States Special Rapporteur on Freedom of Expression, and the African Commission Human and People's Rights Special Rapporteur on Freedom of Expression and Access to Information. So keep in mind that almost every international organization, whether it's the UN, the OAS, or the AU, rather the African Union, they all have special rapporteurs or special sort of scholars or experts in the field who monitor a specific issue. So for all of the essential international organizations, regional organizations, and the UN that have special rapporteurs on freedom of opinion or expression or the freedom of media, they were all part of this joint statement about fake news. And the first thing that you actually see from the joint statement is how important all of these individual organizations value free speech and freedom of expression, because they say that states can only impose restrictions. So it starts off essentially by saying people should have the right to freedom of expression, but states can only impose restrictions on the right to freedom of expression when those restrictions abide by the following. They have to be provided by law. They can't just be created. They have to follow the legislative process of a country. They have to serve one of the legitimate interests recognized under international law. Now, you remember the legitimate interests that I mentioned to you before: national security, public order, health and morals, all the things that we talked about with Article 19 and Article 20. It has to be necessary and proportionate to protect that interest. So you can't have a blanket limitation on freedom of expression just to stop some few instances of hate speech or incitement to violence. So that's the test, essentially, that you have to pass if you're trying to limit freedom of expression. But it also gives the right of a country, this joint statement, to stop individual or to punish individuals who are engaged in hate speech, right? So it says that states can prohibit advocacy of hatred on protected grounds that constitute incitement to violence, discrimination, or hostility. And this is all copying the language from Article 20, subsection 2 from the ICCPR. So again, remember, the American jurisprudence and American law might look at incitement to violence as being the most important thing. But under international law, even from the ICCPR and from this joint statement from the OSCE, the OAS, the African Union, they're saying that it's not just incitement to violence, it's incitement to violence, discrimination, or hostility. So the hate speech doesn't have to incite necessarily violence against a group, but it can, if it does incite discrimination or hostility even, it can be prohibited and it can be punished under law. That law has to be, again, for a moment to go back, it has to be provided for by law, it has to serve a legitimate interest, and it has to be necessary and proportionate to protect that interest. So keep that in mind. It's not just a blanket provision that you can create as a limitation on freedom of expression. So let's see what else the joint statement says. Then the next thing they talk about is actually intermediaries. And intermediaries are actually probably either the ISPs or the internet service providers, rather, or the platforms themselves that host third-party individuals posting things on their website, like Twitter, like Facebook, like MySpace, all those things, right? So the rule that it starts out with is actually intermediaries should never be liable for what a third party posts or third-party content relating to those services unless, and this is an important unless, they specifically intervene in that context or refuse to obey an order adopted in accordance with due process guarantees by an independent, impartial, authoritative oversight body to remove it. Okay, so the first part of that talks about if the intermediary engages or has intervened in that content, right, in some way, shape, or form, if they've magnified the content, if they've sent that content to a lot of different people, the website did that. So if the website did that, or if the ISP did that, then they are going to be held liable for whatever that third party said. If they didn't do that, then the alternative is that they might not be held liable for third party content, but where they could be liable is if there's a court that followed due process, right, and said, hey, based on our laws, this person's post on Twitter talking about a minority group should be taken down. If that order is given by a court and it follows due process procedures, then the intermediary can actually be held liable for what the third party said if they don't abide by the order. So essentially, there's two elements they're looking at here. They're saying if in some way the ISP or the platform like Twitter or whatever is engaged in content moderation or is engaged in content sort of favoring or magnifying, then they're going to be held liable for what they're trying to magnify. So if they're trying to magnify stories by InfoWars or by hate group, then whatever the hate group said in that tweet or whatever they said in that Facebook post, because Facebook or Twitter is promoting it, then you're going to be held liable for that content, right? And the other way that they can be held liable for third-party content is if a government body, like a court, goes through a due process hearing and says, hey, we looked at freedom of expression, we looked at the hate crime legislation, this post should be deleted because it violates our hate crime provision. If you don't abide by that court's judgment, then you're going to be held liable as a Twitter or Facebook for not taking down that content, even if it was created by a third party, right? So it's not created by the person who's running Twitter or Facebook, it's created by a third party. But in these two instances, you can be held liable because either you magnified that content and you promoted it, or you didn't follow a court order to try and stop it. So let's talk about the other sort of element here. What happens when a politician retweets a hate remark or on Facebook likes a remark that's racist or that has discriminatory language, et cetera, et cetera? It says here in the joint statement by the OSCE and all those other organizations that I mentioned earlier that state actors should not make, sponsor, encourage, or further disseminate statements which they know to be disinformation, fake news, or they know to be propaganda, right? So these are the really important elements to remember here, that while we might not want to keep, the general rule might be to not hold Twitter and Facebook responsible for things that third-party people post. What we do say is for state actors who are on Twitter or on Facebook, they shouldn't make, sponsor, or encourage, or further disseminate. So they shouldn't retweet, they shouldn't like on Facebook, right? These are things that state actors shouldn't do. Things that they know or reasonably know to be false or to be propaganda, right? So this goes to the underlying international right to be free from propaganda, to have the right to information and impartial, non-discriminatory, true information, right? So here what we're talking about is that let's go beyond just these websites or these platforms themselves. Let's look at the state actors. And if state actors are using these platforms to like and to promote hateful information or hateful messages, then, right, there's a permission to stop that, to punish that, and that wouldn't be a violation of international law, and it wouldn't be a violation of freedom of expression, right? So that actually wraps up most of what I wanted to discuss as it relates to freedom of expression, Articles 19, 1, 2, and 3, Articles 20 of the ICCPR, subsections 1 and 2. Also look at the European Convention on Human Rights, Article 10, and look at some of the links that I have in this PowerPoint. If you have any questions, you can contact me at wxhusalaw@gmail.com, or you can contact the competition organizers if you have any more questions about the competition itself as it approaches. We're finalizing the compromise now, and it should be going out very soon. So for all those interested, please do make sure you follow the updates at your law schools in Kathmandu, in Pokhara, and the other places that we're trying to get schools to come to compete. And then you can talk about this very interesting issue, right, of international law, emerging customary international law, Articles 19 and Articles 20, freedom of expression, hate speech, hate crimes, incitement to violence, all the stuff we talked about today, which again is an emerging form of international law, of customary international law, of treaty law, but is certainly something that's driving a lot of conflicts today. And if it's driving a lot of conflicts today and there's reasonable minds that can disagree on it, you should believe that it's going to be part of a moot court competition as it is for Nepal. So best of luck to all of you. And if you have any questions, let me know. Thank you.